Hello, welcome back, everybody. I will wait 1 minute whilst people come back into the room. And by 1 minute, I mean 30 seconds. Thanks everyone for coming back. And you are seeing my face again, as mentioned last panel, I was standing in for Jess from Ofcom. This panel, we are joined by two expert guests, Julia Troiano from Hausfeld and Manon Baer from the Five Rights Foundation. So Julia is a practicing lawyer who's also one of the, I think, top 100 women in AI ethics, who's recently completed her kind of master's in AI ethics and society at the University of Cambridge and writes extensively on the intersection of AI, culture, and society. And Manon is leading EU advocacy efforts at the Five Arts Foundation, who have recently, among other things, published a significant report on AI age-appropriate design. Is that Children and AI Design Code? Perfect, you've got it there, Manon. Thank you. So for anyone who doesn't know, the Five Arts Foundation are a small but mighty NGO who have a real big impact on the online safety landscape. They've been pioneers behind the age-appropriate design code, for instance, which sets out how GDPR applies to children and has been kind of translated from the UK context overseas. So it's had a real international impact as well. We've just spoken a bit about how AI harms manifest and some of the kind of broad technologies that are already being used to try and counteract that harm. And as was mentioned on that panel multiple times, it's not just about technology. You can't rely on techno solutionism here. You need smart policy, regulation, and you need lawmakers to think carefully about how they respond to these new emerging threats. My background before setting up Illuminate Tech was at Ofcom, where I kind of witnessed the passage of the UK's online safety bill, saw all these amendments being thrown at it left, right, and centre. And one of the challenges during the passage of that bill, now the Online Safety Act, was this acute awareness of how quickly the threat vectors in this space evolve. So when you're designing primarily, well, legislation and then regulations, which kind of set out how that legislation applies to platforms in practice, a big challenge for policymakers is how can we create regulations that are going to be sustainable, that are not going to become outdated incredibly quickly, and also that recognize the international scale of these threats, right? Countries tend to pass legislation which apply to themselves. Obviously, you have things like the EU, which is slightly different. And yet these threat vectors come from all over the world. So today we're first going to talk a bit about what does the current legal landscape look like? How fit for purpose is it at helping us to counter some of the threats we're seeing from generative AI and more broadly kind of AI facilitated harms? We're then going to move on to discuss some novel ideas for how legislators might choose to respond to these harms in future. And then we'll go into a bit of discussion about some of the challenges that legislators are facing in this space. So without further ado, I will hand over to Julia, I believe, to kick us off.
Sounds good. Thank you very much. And I think, yes, it's a nice segue from the first panel in many respects. So from a UK point of view, I think, the framework is patchy. There are positives and negatives about this, but starting from what we do have, as discussed in the first panel, there are there's criminalization of intimate sexual deepfakes. As George will know, this was done via the Online Safety Act, and that was about the distribution and sharing of images, including deepfakes. And then following further campaigning, most recently in July, we had the Data Use and Access Act 2025, and this introduced a new crime which relates to the creation of these images, which was the sort of controversial missing limb. And we can talk about how you enforce the creation probably later. So we have this. We also have a helpful guide from the UK Police, but this is obviously reflective of the law that is in place. That where you have deepfakes that are used, for example, to perpetrate fraud, for hate crime purposes, these would all fall under current crimes, and so therefore can be persecuted. But when we come to a sort of a wider review of what other sort of AI specific legislation we have in the UK, that's where the framework is indeed patchy. So we had the white paper back in 2023, and what that set up for the UK, almost in antithesis, I guess, to the EU AI Act, which Manon will touch on in a bit, is that rather than having this standalone omnibus legislation, the directive would be okay, you have really excellent regulators who are specialized in their fields. Why don't they go ahead, look at what they think is a regulatory gap? They have the skills and knowledge, and then they can come up with potential proposals as to how to fix these gaps. And this then resulted, of course, in the DRCF, which is the Digital Regulators Cooperation Forum, being set up with Ofcom, FCA, ICO, and the CMA, which is the Competition Markets Authority. So that's all well and good, but yes, we don't have a standalone act. And most recently, I think people might have been familiar with the debate that was taking place in the House of Lords in relation to the Data Use and Access Act, as it related to, again, it related to the use of copyrighted material and remuneration for creators. But as we will probably discuss later, this obviously has an added element with regards to deepfakes of, for example, someone's likeness if they're an actor, and we can see what has happened in the US in relation to this a bit later as well. And yes, I think that's my broad overview before we hand over to the EU AI Act, which is obviously much more detailed.
Yeah, much more detailed, the EUA Act. I mean, so it's a broad piece of legislation that tries to covers everything. At the end of the day, it's a product safety legislation, so it's much bigger. But in some ways, it also doesn't cover everything. I mean, you were talking to begin with on criminalization parts, so those are covered by other types of legislation at European level, which is also complemented by national legislation. So yeah, as George was saying, the EU is, is what it is. So we get to have the EU level and the national level. Which sometimes can be, both positives and negatives. But yeah, looking at the AI Act specifically and deepfakes specifically, so the AI Act does provide for definition of deepfakes, which is any types of AI generated or manipulated images, audio or video content that resembles existing persons, objects, places, entities, or events, and would falsely appear to a person to be authentic or truthful. So it's quite a broad definition in the sense of what we're looking at. So it's not only people, but it's also objects, which can encompass a lot of things from artworks to products, entities, also meaning that we're not only looking at specific people, but we could also be looking at, trying to misrepresent corporations or governmental entities, all of those things. And then, yes, there is this idea of being authentic and truthful. So it's not only about misleading impressions, but really about distorting reality. The AI Act per se doesn't ban deepfakes completely. It just sets transparency requirements on two types of people within the EU AI chain. So the EU Act is trying to look at the EU supply chain all over. So we have different types of people that have different types of obligations. So we have the providers who are the one who actually design the AI systems and the AI models, and then we have the deployers, the one who actually use those AI systems. And both of those will have some kinds of obligations in terms of transparencies. So the providers, they need to ensure that any type of outputs are marked in a machine readable format and detectable as artificially generated or manipulated. And so they need to have some kinds of technical solutions in place, which could be, watermarks, metadata identifications, all of those type of things. And they need to be effective, interoperable, robust, and reliable as far as technically possible. And then we have some obligations as well as the level of the deployers who need to disclose that the content has been artificially generated or manipulated. So this disclosure must be made clearly and distinguishedly, so it's a labeling disclosure. And the idea to have them both at the provider and the deployer level is that sometimes if you're, for example, deploying at a non-professional level, so at a personal level, then you won't necessarily be under the AI Act, but we still want the AI outputs to actually be recognized. So that's why you need the providers to have these technical solutions for identification. Just to note, the AI Act actually is already into force, but its obligations are becoming applicable in a rolling manner. So this will only be applicable next year in 2026. And the Commission, so while the AI office may issue guidelines in terms of looking at technical solutions, for example, or codes of practice can also be developed in that sense. So that's the AI Act specifically on deepfakes. It's a broader legislation in the sense of like you have some types of AI systems that are considered so dangerous that you will prohibit them. If we look at children, for example, we know that AI systems that are aimed at manipulating them and that will have a high risk of harms will be manipulated. We also have certain types of AI systems that are considered to be high risk and then will face a series of obligations. But in general, when we look at deepfakes, yes, that's mostly what we have. And I think compared to what you were saying, Julia, we also have in certain legislations sometimes a criminalization of deepfakes. So if we look, for example, at the directive that came out last year on combating violence against women and domestic violence, here we also have the criminalization of deepfakes, so of non-consensual images generated with AI. And so that legislation actually requires member states to criminalize those type of images because it's directive. And then we also have the CSAM directive, which is still under negotiation. But like actually a few weeks ago, the European Parliament came out with this mandate, which very strongly actually mandates the criminalization of the creation, possession, and sharing of child sexual abuse materials generated by AI. So similarly to the other directive, that actually means that member states in their national legislation will have to criminalize any type of creation, possession, and sharing of child sexual abuse materials. And I mean, I think also, if we want to look broadly at it, we also have some stuff under the GDPR and the DSA. So trying to, cover all of the different actors in the platforms. So if we look specifically at the DSA, I mean, we know that at the end of the day, deepfakes are all over social media platforms. That some app stores also have, certain types of apps that actually helps the creation of deepfakes, especially if we talk in terms of notification apps, for example. And both of those will have obligations under the DSA. So we have beautiful Article 28, which required online platforms to ensure high level of privacy, safety, and security. And just on Monday, actually, the Commission published its guideline on that article. One of our asks was, of course, that they need to look at AI. I mean, more and more of social media platforms have certain types of AI features that are actually included and part of this, and it provides for actually like some certain types of specifics requirements. So they need to ensure, for example, that technical measures are implemented to warn minors that they're interacting with an AI feature and that these features can actually provide information that are inaccurate. So there's different types of obligations there and there. And I mean, one of the things we were concerned is that a lot of the social media platforms push children to interact with AI. So if we look at my AI, for example, of Snapchat, it's being made as like the first thing you talk about. It's a bubble of your friends. It's going to actually, send you a message, try to interact, etc. So we wanted to make clear that those things should not be done. And that's one of the things that the guideline does, which was really important for us. And next to that, I mean, the very large online platforms, so the big ones, Snapchat, Facebook, Instagram, TikTok, there's 25 out there. They also have this requirement to analyze any type of systemic risk and to address and mitigate those risks. So we saw actually in some of the risk assessment that came out last year in November that some of them had actually considered, generated AI content and deepfakes as a systemic risk, not only to children but also to misinformation and disinformation, and that they were putting in place certain types of mitigation measures. I'm not going to speak more about those risk assessment because they were really terrible in general, but they actually do recognize those as systemic risk and recognize their obligation to actually act on it based on the DSA.
Thanks so much, both. I think there's a lot in there. So to summarize really briefly, efforts are being made, a little patchy at the moment, perhaps, but we can also apply existing legislation to AI facilitated harms. I think the concept of a kind of AI or deepfake supply chain is really interesting. So where the legal and illegal activities take place along that supply chain, in everything from the gathering of data to train the models, the training of the models themselves, the dissemination of those models. And I think we had a question in the last panel from Mashila from South Africa, I think, asking about boys in schools increasingly deliberately abusing generative AI tools to target girls in those schools. And I think a big question in this space generally is who is going to be held responsible for these kinds of harms taking place? Because there, obviously, you have the boys being the bad actors. It might also be that more should have been done before those boys even got access to those tools to perpetrate that harm in the first place. So I think that's a really good overview of where we're at in the EU and UK at least. I'd love to move on next to what emerging ideas are there to try and kind of shift the dial forward slightly and better address some of these harms. So I will hand over to Julia first of all.
Yes, and actually, just on the, if I can just add a point on the pipeline, just in terms of responsibility, I think that's a really valuable point to make. You have, for example, the App Store often providing apps which are accessible by minors when they shouldn't be, or when even the app's own description says that they're suitable for a particular age, but then are available to people who are obviously under that age. So just to point that out as well. In terms of emerging ideas, I think one of the things that I'm particularly interested in is the idea of personality rights or image rights. So to give a bit of backdrop to that, obviously we have discussed, and for good reason, why we have the criminalization of, sexual deep fakes relating to both adults and very disturbingly also minors. But there's obviously another category of harm which relates to, people who are deep faked, but in just a video, or you have, I guess, your example, George, of the Pope with the Balenciaga coat. Now, within that, you then have a further distinction between, I guess, the likes of us, we're not, celebrities, and then you have celebrities, working actors, public figures, politicians. So what has happened in the past is that, especially following, the Hollywood strikes, legislation has been put in place, for example, in California, which sets specific requirements as to how deepfakes, in this case, digital replicas effectively of an actor might be put in use. And as of January 2025, essentially, for those who are negotiating rights, they have certain protections. So if their performance could have been done live, if they are not represented by lawyers or by a union that has already expressed a position in this regard, there are certain protections put in place such that no one could use their likeness in, let's say, a future film or dubbing, et cetera, et cetera. And the same has been done in New York, for example. But then you have another layer, which is, what happens to people like us, where we might then be included in some form of deepfake audio or video content, but we're not public figures. And so the concept of personality right has come to the fore a bit more most recently in Denmark, because Denmark is very keen to introduce essentially a right for all individuals in relation to their facial features, their voice, and that would then give you a right to go to a platform and say, please take this down. I have not consented to my likeness being used in this way. Now, it's really interesting, and I think that there is obviously debate surrounding whether or not it's enforceable. In Denmark's case, it's still obviously going through the procedure, but it would just be applicable to Denmark. At what point do you blame the user who's trying to generate this? Do you just blame the platform? In the current version, they're just essentially putting responsibility on the platform for not taking something down. But more widely, it's an interesting proposition because the Danish version gives you a right in your own person, which is a bit like a moral right, effectively. And then you go back to the US, and the US is currently debating something slightly similar, but with a very different, moral compass potentially, which is the No Fakes Act. And again, that relates to every one of us. We have a likeness, but the way it's being framed there is not so much as a privacy or, I guess, moral right to your own person, but it's framed as a property right. So there, the idea is that you have the right to your likeness. You can't assign this. You can license it, though, and make money out of it. And then upon your death, your estate or whomever you have passed your likeness in your will to can then exploit it in a market sense. And interestingly, many companies like OpenAI, like YouTube, the big record companies have expressed support for this new version of the No Fakes Act. And so there you have the ethical consideration of, do we want to create a marketplace for effectively licensing yourself, or the possibility of licensing yourself, or do we want to take more of a moral stance as to whether this should be allowed from a different point of view? So those are points that I find quite interesting. But as to obviously the application of them, I'll just add one point, which is, obviously, in the context of public figures and celebrities, the reason why some of these are interesting and creative is because they are satire, parody, etc., etc. And we have seen, a trend towards repression of press across the board. So there's obviously implications as to the nature of these rights and how they might be then abused by figures who might not agree with, I don't know, the political position that you're putting forward in a deepfake video. Now, flip side to this, not to get into a full ethical debate, is you can of course do satire by not creating something that is identical to the person you are satirizing. And I think in an environment politically that is incredibly strange, where often you don't know if a headline is a joke or real, alligator Alcatraz being one of them, frankly, is this the right approach? How much should we provide by way of protection to satire and parody? Should we have further carve outs? Is that potentially an infringement on press rights, etc., etc.? So I think these are all big questions which need to be thought about. Yes, and I think I will end there on the kind of perspective. And the last point, in the UK, in terms of personality rights, these don't exist. But again, you have a bit of a patchwork that you can apply. So you have passing off trademark to the extent that, again, you're a known personality or someone's trying to ride off your, capitalize on your personality as a way to make money. But again, for the likes of us, that's not necessarily such a great protection.
Thanks so much, Julia. It is remarkable how a lot of discussions that previously would have felt dystopian or like an episode of The Simpsons set in the future are now they're really urgent, aren't they? And all the while, I think one of the challenges for lawmakers, policymakers, is how do you keep up, right? Because all of the bad actors in this space are moving fast. They're not thinking about are we adhering to the data collection principles when we're developing this deepfake training technology or whatever it might be. And I think this is where civil society actually has a really important role to play. And with that, I will segue into, if Manon, this is a good time to segue into it, the work the Five Rights Foundation have recently done on this, which is really valuable work, helping to support policymakers in how they might want to think about some of these problems.
Yeah, and I think it speaks to a lot of like, where do you put the responsibility and for whom? I mean, as Five Rights, we've always kind of moved away from it's an individual responsibility. A lot of it is, systematic issues that we see, and those systematic issues comes from the way innovation was actually thought through and designed, right? So I think there as well, it's, they should be also recognition as like how we deal with innovation and technology, like how do we think about it? We need to start from the perspective of like, it's all being created and humanly engineered. So, the way those technology and those innovation actually come out is not just random, right? Like there's a specific purpose behind. There's like specific things that have been put in place. There's specific types of interests that are being pushed and others that are also being forgotten. And so I think it can speak broader afterwards about, what are the challenges, but I think sometimes one of the challenges that people see innovation as this magic thing that just, come from the skies and falls, and then suddenly we have to deal with the risk. And, before it's up there, it's in the minds of those brilliant people, and there's nothing that can be done. And then afterwards we actually see the risk. And from the Five Rights perspective, this shouldn't be how we accept technology and innovation, right? Like innovation shouldn't just come and then as society we have to deal with the risk. No, as innovators, you should also recognize that you have a responsibility, that you live within a society, that you live within a democratic framework, that you should respect the legislation that are already in place, but also that your innovation should come, first of all, with like this idea of like, okay, I will try to make it people-centered. I will try to ensure that there's as little risk as possible. And at the end of the day, that's what we have been trying to do, at Thrive, with like safety by design principle, rights by design principle, this idea of you should always go back to the products and the way you design it and ensure directly, from the get-go that you have as little risk as possible. And in a sense, that's completely tech neutral, right? Like whether you're talking about AI, whether you're talking about social media, like you can do this and apply this across the innovation sector. The idea for us to have, a specific children and AI design code was also to reframe that conversation and be like, this is not magical. First of all, this is technology, and as it is technology, it can be changed, it can be made differently. And if you actually start by looking at how children are, what are their needs, what are their ability, what are their rights, and you start asking yourself the right questions throughout the AI life cycle, then you might actually come up with a technology that is much more right respecting and that will provide way less risk. And that's why the AI and design codes actually aims to do. It's basically a document that gives you a series of questions that you should be asking yourself at each of the stages. So whether you're, preparing and setting your intentions, whether you're going through your data sets, whether, you are designing and, asking yourself, what am I actually aiming to do once you're putting actually the AI system out there? And then also, of course, like reporting, making sure that while your AI system is out there, it's doing the right things that you want to do. And then even when you're decommissioning. So it's like throughout all of that, ask yourself the right question and make sure you're actually abiding by those principles. So that's what we're trying to do. And yeah, it's very much about redesigning for children. So I think it's this idea of like, we should stop just pushing on innovation and then expecting people to adapt to it, but we should actually make the innovation for people. And we know that, children are particularly at risk. They have particular needs. They have particular requirements. And I think the AI code was also a way for people to recognize how AI impacts children differently. I mean, I know this is about deepfakes, but, AI impacts kids in so many different ways. And it can be about their privacy. It can be about their education, I mean, their health, like literally all of those things. And the code aims to, help you kind of navigate how children are impacted by AI and how you can make sure that it's actually a positive impact broadly rather than a negative one. But yeah, it's available on our website, and I encourage, of course, everyone to have a look at it. I think for us, it's also very much of a work in progress. Like, I mean, I think as everyone, we're learning as we go. But at the end of the day, I think the basic principle and the premises are very much still the same when you're talking about innovation. Innovation is humanly engineered, and it can be engineered in a different way if you start from a different perspective. So that's also what we are saying with AI, basically.
Thanks so much, Manon. I think I want to look backwards to the last panel just briefly, because in the pre-meet for the previous panel, Ami, I'm stealing Ami's point, but he raised a really interesting point. When he was going through fundraising for Contrails AI, an idea he had was, how do you actually incentivize these innovators to be responsible? Where are the levers for change that regulators could use? And one is, if VC firms had to, before investing in an AI company, ask questions about, have you been through this risk assessment process? Have you thought about the risk of harm, as well as the kind of potential for funnel growth or whatever it may be? If those questions were asked at the investment stage, that would massively incentivize these companies to design more responsibly. So again, full credit to Ami for raising that point. That's not my point, but I think it's really relevant here. Manon, do you want to come in on that?
Yeah, I think it's super interesting that you mentioned that, because indeed it's like how you do, how do you incentivize, and you can do it at the investment stage. I think for me in this space, we always talk a lot about digital literacy, right? Like companies and a lot of people love to come up with this thing of like, okay, we need to educate children and we need to educate the people that are actually using the technology. And sometimes it's like, wait, shouldn't we actually educate the engineers and the people who are doing this technology to do this in the right way to begin with? So it's also like, where do you put the responsibility and how can we, change this from the beginning? I think when you talk to a lot of, engineer and people in this space, they're living in their bubble and they don't necessarily understand or consider all of the impacts that are coming with whatever they're doing. I mean, my brother is an engineer, and like, it's like sometimes it's those typical dudes that just think they're doing cool things and it's just cool, and they don't actually realize all of the impacts of what they're doing. So I also feel like, there's a shift in how we need to think about innovation, and that shift needs to be taken at so many different levels, but it shouldn't start from the end user. It should start much earlier. And investment is one of them, but like development, engineers, like all of those people need to be also educated.
Yeah, 100% agree. We've kind of stumbled upon the challenges with kind of doing smart legislation naturally, but I want to kind of ask that question specifically to Julia about what challenges you think specifically need to be overcome here, and in particular, what kind of limitations are there around enforcing legislation that already exists.
I think it's largely a big challenge we currently face is the attitude that our politicians have to this, frankly. So, if we go back to what I was mentioning in terms of the UK's framework, whilst I can't say I agree with the government that put out the white paper conceptually. The fact that you have regulators who are well steeped in their particular fields is not a bad system. You know, they are the ones well versed in understanding what legislation is applicable. And I think I'm a big believer in not reinventing the wheel just because something says AI. We have a lot of narrative around AI exceptionalism, which is largely driven, frankly, by industry as a way of saying it's all too complicated. Copyright can't possibly apply here because us scraping data is so transformative that you can't apply the same rules as you would in any other circumstances. And this is being sort of bought into. Whereas if you allowed regulators to have the mandate that was originally envisaged in the white paper, they might be able to simply look at actually, do we need to reinvent the wheel here? You know, in the context of employment, for example, we have anti-discrimination laws. We know that, for example, algorithms have particular impact on biases. This, frankly, is also reflected sometimes in what you get if you try to create a deep fake, right? So there are opportunities to make use of existing laws, but it does require a bit of boldness, both from obviously, you know, the likes of my firm when we try to bring claims and we try to be very innovative about it, but also by the regulators, and the regulators need to have support from the government. And recently, we have seen that in the name of a growth agenda, a lot of the powers have been sort of regulators have been invited to step back a bit from attacking industry, when in reality, if you think about a growth agenda, that also involves, you know, making sure that people are competing, one, in a fair way, but two, allowing competitors who actually look at the ethical life cycle of how they obtain their data, who are devising really innovative solutions, and not just kind of back off. So I think that's a big challenge. And the second one that I would just add is that there's also an annoying normalization of the technology. I think this has been raised by the previous panel. So I remember when Google first released its AI editing app where you can like erase people in the background, right? Now, as you said, George, I think in the first panel, we've had Photoshop for a long time, but it's quite different to have Photoshop and then to just have your photo app on a phone. And basically this phone, you know, has a significant market share, and you just allow people to like erase humans in the background. You know, the normalization of that for someone using it, for kids using it, for anyone, also creates a bit of an issue in terms of then getting to people to consider, why is that problematic? Again, why are we polluting potentially the information environment? Because this will then have ramifications in terms of, you know, civil evidence, criminal evidence. There's obviously serious harm that can happen, but it all starts with you know, day-to-day interactions and the day-to-day attitude of governments to this. Yeah.
Thanks, Julia. Yeah, Manon, how are you seeing this kind of AI boosterism play out at the European level?
I mean, I think it's not that much different as, you know, as in the UK. I think it's like it's globally what we're saying, right? We're seeing a really big shift from AI safety to AI innovation. Like I think at the European level, it's also really clear. During the last mandate, you know, the AI Act was really portrayed as the EU being so innovative in its regulation and, you know, really setting the international scene for what good legislation regarding AI should be and how we should consider the risk and like use the technology, but, you know, still ensure that you have fundamental rights that are being respected at a basic level. And there was really this willingness that you also saw from the EU to, you know, go around and be like, hey, we've done this EU AI Act, please look at us. And, you know, we can go into discussion on to how to do this for you guys as well. And like right now, if you look at what's happening at European level, all we hear is like, oh, we need to create the EU as the new AI continent, right? Like we're always talking about, those AI factories and where they should be, and like how we can, make sure that the EU is not losing the international race for AI against China and the US. And so that's a very different framing. I think it's also, of course, coming from this growth and competitiveness and this idea of, that's also what you hear from a lot of companies, right? That if you start to regulate, then you will reduce innovation, that you'll impede innovation from continuing, and that basically regulation is against innovation. And at this point in our day or age, all we should have is AI, because apparently that's going to save us all, right? So it's a bit this very different narrative. And I think it is very clear also looking at the specific legislations that we have. So the EOA Act is this big massive legislation, right, that requires also so many secondary instruments. So we have the code of practice on general purpose AIs right now that were being actually drafted during the last year. And we've had so many calls from industries, but also from the US government, to actually stop the implementation of the AI Act or to reduce some of the obligations, or really very much to kind of weaken the code of practice that, from our perspective as civil society, was already really weak to begin with. Especially when we talk about deepfakes or child sexual abuse, in the code of practice, it wasn't even considered as a systemic risk to begin with, which is insane. But that's where we were starting from. And I think we see also, because of where the US is and with the role that those big tech companies are having, we're seeing this really play out at European level as well. Lobbying on digital legislation has is at a all-time high, and it's like one of the sector where actually industries are investing the most. And that means that when you look at some of the secondary instruments, but also like standardization process, you need standards like across the UA Act to be able to enforce it. You need standards on everything. How is the standardization process being done? It's mostly actually being done via companies. Like those companies' representatives have so much power within those institutions as well. And so now, we are hearing that those standards won't be ready in time, and so we shouldn't start enforcing because we won't have them in place. Yes, but who has been preventing, those standards to be in place in time, and making this entire process slower? Well, it's industry to begin with. So it's a bit, I think, a complicated environment. Also in the sense of, if you look at regulatory authorities, the EU being what it is always a bit complicated, in the sense of you will have a mixed match between national authorities and now the European Commission, who is taking certain enforcement powers in terms of digital regulation. So how do you make this entire ecosystem actually works? How do you make DPAs, under the GDPR, work with the DSEs, who's going to work with the AI market surveillance authorities? And through it all, you can also have fundamental rights authorities who will also have a role. So there they will need a lot of coordination, consistency, talking to one another. And for all of that, as Julia was saying, you need political will, and you need that political will at the highest level. And if we don't have that political will, well, yeah, I'm not too sure where we're gonna go exactly. It's the same with the GDPR. Like, it's legislation that has so much potential in itself, but if you don't have the proper enforcement and implementation mechanism to actually make it work, then yes, what you actually get at the end of the day might be much lower. So I think it's a specific time we're in. I don't know, Julia, if you want to add on more.
It was just a small point, which is, sorry, I'll lower my hand. A small point to say that I think on enforcement, it's very true that sometimes it can be really complicated. But what's missing sometimes in the political discussions is that, yes, that we should try to make laws and regulations that are as enforceable as possible, but sometimes sending the message out is equally important. In the sense that if you don't even consider it a big enough problem to make an attempt, then it really undermines what a lot of civil society and a lot of other initiatives are trying to achieve in a kind of grassroots kind of way, which is really, really valuable. But yeah, I think the top-down sort of attempt is really important too.
And I think, when you look at enforcement as well, and when we talk about the digital environment, you have really very powerful players that you need to deal with, right? And I think at European level, that's also why there was a recognition when you look at the DSA and the DMA of okay, we need the European Commission to actually step in, because you need somebody who has all of the capacity behind. When you look at some of those companies, they have bigger revenues than some of the European countries' GDPs. So there is also this power imbalance sometimes that you need to take into consideration. And then once again, that requires a lot of political will for any types of regulatory authority to actually step in to those, digital service product providers that have these massive powers and that regulates, so much of our lives. Right now I'm in an Apple computer. I was using Word before. Like all of the system that we're using also rely on those, big tech digital service and providers that we're relying on. Like for outside, I also know at European level, there's a lot of talks about sovereignty and how do you get there also in terms of tax, like how does it impact our everydays and our ways of, also making regulation and enforcing regulation. If we look at the US and the EU discussion in terms of tariff, well, digital regulation is a lot of times like actually put within those discussions as well. And then once again, it's like big discussion in terms of sovereignty when you're relying on a few actors that are actually not based necessarily within your jurisdiction and might not always be willing to actually play by your rules.
Yeah, 100%. Really interesting stuff. I think whilst we can't necessarily address the issue of Trump's tariffs within the context of Project DefAI, unfortunately, just to tee up the next panel slightly, I do think it's great that Innovate UK are funding not just the development of these technologies to respond to the kind of, and in a Swiss, I should say, to the short-term threats, but also part of that project has been contributing to the development of these standards. And it is really important that you have a diverse range of voices contributing to the development of those standards for the reasons that Manon just spoke to. So, yeah, it's great that Innovate UK and InnoSuisse are doing something to fund at least some solutions to this problem. I want to we have 4 minutes left, and there are a couple of questions in the chat from the last session that I'd love to get this panel's opinion on whilst we have the time. So we had one question asking how sympathetic are regulators likely to be, or should they be, if digital services try to implement safety measures but are defeated by a sophisticated deepfake attack? Does either panelist have a strong opinion on this one?
Strong opinion, no, but just two words, and Manon, I'm sure you'll add something too. Is that, to go back to the point that Manon was making, if you ask the right questions and you put procedures in place, then at least you can be comfortable that if something does fall through the cracks, you really have attempted. But at the moment, I don't think we have, I don't think there's been sufficient attempts to do so. And you go back to the business model of many of these companies. So I think they can really be sympathetic in extreme circumstances, but I just don't think we meet the threshold at the moment in a lot of ways. So that would be my personal take. Also, side note, it's not really their job to be sympathetic. So I guess, ultimately they need to ensure that whatever regulation is in place is being followed. And it's important to have a cooperative dialogue as to the practicalities of implement it. But, that's where it goes.
I think when you look at European regulation, a lot of it is also risk-based now, right? So it's also you recognize the risk and you try to put in place the right mitigation measures, taking first of all safety by design, but then mitigation measures approach. So in that sense, it's a lot of process obligations, which are good to start with. So in that sense, it's like, yes, if you try to put, the right things in place, if you have safety measures to begin with, if you have the right people monitoring it on the ground, if you have the right mitigation measures, if you're talking to the right people, if you're engaged, if you're doing your utmost best and something is still not working, then okay, we can work on this. And I think regulators would be more likely to be like this. I'm not going to go against you because you're trying to do your best. I think on the other hand, we also need to what Julia was saying, we need to decide what is our threshold. Working specifically on children, that's also one of the things we've been saying, like innovation should never come at the disregard of children's rights. We should always at least, protect this layer of a society that's, what we have signed up to as countries as well under the UNCRC. So where do you put that baseline where you should never go under? If you look, for example, at the DSA, yes, you have this whole idea of, doing risk assessment mitigation measures, but under Article 28, you also have an obligation of results. You have an obligation to ensure high level of privacy, safety, and security. That obligation is an obligation of results. That's what we're asking you to do. And so I also think maybe that's a discussion we need to have, but as society, maybe we shouldn't necessarily always be okay with innovation, just going out when it's not ready to be out. So, there is also a discussion there as to maybe, okay, well, we can recognize that this technology is happening, but it's not ready for society, yes, because it has so many of those risks. So it shouldn't be out there in the public, or at least, for certain types of vulnerable positions, such as children. So I think it's a bit of a mixed one. Speaking specifically for the regulators, I mean, especially as they're enforcing new regulations and new legislation, they're looking at the most egregious acts. I mean, I know at European level, if you look at how the DSA is being enforced against very large online platforms, of course, they're going to start by looking at the ones who are really not making any kind of efforts, because they're also the easiest one to go after. So I think for them, it's also, a way to make your point really heard, at least try. That should be, your basic starting point.
Yeah, 100%. I think we're at time now, but completely concur. Really clear risk assessments where you're thinking about what evidence are we looking at, how are we quantifying risk, how are we mitigating risks, which we can come on to speak about one technique for doing that in one context in our next panel session, which is looking at the deepfake detection technology in the context of age estimation that Project DefAI has been funded to develop. But clear risk assessments, transparency before the rollout of novel technologies, I think is it sounds dry, but it's super, super important. Okay, so with that, I will thank Manon and Julia for their time and expertise. Yeah, really appreciate it. Really fascinating points made. And I think we will go straight into our next panel. So I'm going to hang around for that one, and we'll invite our other panelists onto the stage.